Hi everybody, Matt Quinlan here. Welcome to another edition of Whiteboard Wednesday, where we tackle the real life issues that our clients face and we answer questions that we get from people that call our office. This week we're going to be talking about dog responsibility and the level of legal responsibility a person has for their dog. I'm a personal injury lawyer. I get a lot of calls from people that have been bitten by a dog. I agree to represent them, and I get in touch with the dog owner and explain what's going on and explain that my client's going to be bringing a claim. And I am shocked the amount of people that have no concept whatsoever of the laws that affect their dog and their responsibility for the dog. So this week we created a Whiteboard Wednesday to educate and inform people about the legal responsibility that they have for their animals. So let's get into it. The first most shocking thing I think that people find is that they are strictly liable for their dog's bad behavior. If your dog bites somebody, you're responsible for the damages. Plain and simple. It doesn't matter if you were the most reasonable dog owner in the world. It doesn't matter if you took every single precaution. It doesn't matter that your dog's always been so sweet and never even growled at anybody before. If your dog bites somebody or jumps on somebody and knocks them over, injures them in some kind of way, you are going to be responsible. There is no excuse. So that should really wake you up. You have an animal that you love, obviously, but it's still an animal. It can still be startled. It can still be made angry, and animals bite people. And if that were to happen for you, you're going to be held responsible. Now, what are you going to do about it if you're held responsible? Well, you're going to get a phone call from somebody like me or an injured person that's going to be looking to recover for the dog bite they had, the medical bills that they have, the scar that they might have, the pain and suffering, obviously, that they might have. You're going to have probably a hearing with the city that you live in about your dog's behavior. Obviously, municipalities aren't going to allow animals to be roaming about that are biting people. So you're going to find that it's a lot more complicated than just some little snip that's no big deal. It is a big deal, and you should do what's necessary to protect yourself. So, how do you do that? Well, you get insurance, okay? Renter's insurance and homeowner's insurance will cover you for your dog's bad behavior. If your dog bites somebody and, whether it be in your home or whether it be at a dog park or out and about in some kind of way, your renter's insurance and your homeowner's insurance will cover you for that. They will also pay for an attorney if it's necessary to defend you in the event you get sued. So having renter's insurance or having homeowner's insurance is a great thing. It covers you financially, so you don't have to come out of your pocket for the damages, and they will also pay to hire an attorney if it ever came to that. So really, probably the best little small piece of advice you can have is make sure you have renter's insurance or homeowner's insurance if you own a dog. It's really your only kind of buffer in terms of being able to protect your bank account from your dog's behavior. Another possible way that we see occasionally is your auto insurance. If you keep your dog in the back of a pickup truck or something like that, we've had cases like that before, and the dog were to kind of leap out and bite somebody. Your auto insurance will cover you for that. If you're go out shopping with your dog, or you go to a restaurant and you open the door and the dog runs out and bites somebody, or somebody goes to pet your dog through a window and it bites somebody else, your auto insurance will cover you, but the auto really needs to be kind of closely related to the actual incident. They'll be looking to deny this claim if they can, and depending on the factual circumstances, they may be successful. So don't rely on your auto. Shifting gears a tiny bit, San Francisco is a very dog-friendly place. Obviously, I have a dog. People in my office occasionally bring dogs, and employers can be responsible for their dogs, for their tenants' dogs biting and attacking people. The standard is different, okay? There's a negligent standard here. It is not a strict liability thing, so that might seem to give you a little peace of mind, but the fact of the matter is as a personal injury lawyer, I have and will easily be able to make the argument that you having an animal that's loose in your place of business is a negligent act in and of itself. I'm probably not going to be held to the standard of showing you knew it was dangerous or should have known it was dangerous. The fact that you have a place of business and you have an animal running around and it were to bite, a client that came, it were to bite the delivery man, the mailman, that type of thing, you're probably going to be held responsible for that. So you should be aware of it. Now, I, as a personal injury lawyer, would never go after the employer unless I had to. So I'm going to go to the owner, the employee first. I know there's strict liability, and in the event they have insurance, you're probably off the hook, right? But if they don't have insurance and my client's injured, I'm going to be looking to recover from somebody. So I'm going to turn to the employer in this instance, And as an employer, I would strongly recommend that if you're going to allow your employees to bring their dog to work, make sure that they have insurance, okay? Renters or homeowners insurance will cover them, and that will keep you from being, held responsible for something that your employee's dog does. Along these same lines, a landlord. San Francisco obviously has a lot of rental units. I read a statistic somewhere that there are over 200,000 dogs in San Francisco alone. So obviously a lot of these people that are renting also own dogs. And landlords can be held responsible. Again, the only reason a personal injury lawyer or an injured client would want to go after a landlord is if the tenant didn't have renters or homeowners insurance, because it's really all about finding a place to recover from. So if they reach out to the dog owner, the tenant, find that they don't have insurance, and we find out that they are renting, we are then going to turn our attention to the landlord. And the standard is a bit different. It's a bit more difficult to establish the liability, but it's doable, and we've done it. Here's how it goes. You have to establish that the landlord had knowledge of the dog's presence, okay? So obviously, if it's in the lease, if they knew that you had a dog when they rented the place to you, then the landlord's gonna have knowledge of this. If you had dog bowls and toys kind of out and about, and your landlord had been over to your house and it's obvious, that can establish notice. If anybody ever complained about your dog, that'll establish notice. This is usually not that difficult to do, but if the tenant's friends bring a dog over or something like that, landlord's not responsible for that. You also have to establish that the dog was dangerous and that you knew it. As a landlord, it's called dangerous propensity or vicious propensity, and that means basically that you have to be able to appreciate and know that the dog posed a risk, all right? So most of the time I'd say the landlord probably doesn't have actual notice that the dog had bitten somebody before, or that the dog was necessarily likely to bite somebody, but that doesn't mean that you didn't have notice of the dog's dangerous propensity, because you can establish this through showing the breed and the size of the dog. One or the other are a combination. Big dogs, obviously more dangerous than a small dog. Some breeds, if you have a German Shepherd, a Pit Bull, a Doberman Pinscher, some sort of dog that has a reputation for being aggressive, the courts have held that you can use that to establish that the landlord, in fact, did have notice of the dangerous propensity of the animal. And then you can also use the way that the dog is kept to establish it. If there's a big kennel out back that the tenant puts the dog in when guests come over or something like that, obviously that would lend a strong inference that the dog was dangerous and that the renter or the tenant was aware of that, wanted to avoid that encounter. So you can use that to establish dangerous propensity as well. And then lastly, you need the ability to terminate the lease. So, this is probably the easiest prong of this kind of three-prong requirement test. If you're on a month-to-month, obviously you can get rid of the dog. If you didn't give the tenant permission to have the dog in the first place, and you learn that there's a dog there, you can terminate the lease. So as long as the landlord has the ability to terminate the lease, this last requirement will in fact be met, and you can establish a claim against the landlord's insurance company, who invariably is going to have homeowners insurance, and then you find yourself suing the landlord's defending themselves. It creates quite a bit of tension between you and the tenant, and for that reason I would recommend, in a way similar to what an employer would do, is require your tenant to carry renter's insurance. Make that part of the lease, a term, right? So it's like, yeah, sure, you can have the dog here as long as once a year, you send me a copy of your renter's agreement that covers your dog. All right, so that would be something that would kind of keep the spotlight off of you in the event that your tenant's dog were to bite somebody. So that's kind of the structure of things. That's how it works. If you're a dog owner, be made aware you're strictly liable. Get insurance. If you're an employer rather, and you have employees that bring their dog to work, well, maybe you should make sure that they have renter's insurance, because you can be sued otherwise. And if you are a landlord and you're renting to people that have dogs, understand that you might be sued. Again, my recommendation would be require your tenant to have renter's insurance, and that will keep, for all intents and purposes, will keep the claims off you. So there you have it. Hopefully you learned something this week. Kind of the goal was to raise awareness among dog owners. I'm a dog owner, and we want to make sure that kind of what you're facing as it relates to your dog's bad behavior. I appreciate you watching, and I look forward to seeing you again next week on Whiteboard Wednesday.